Today we're going to explore one of the most important and widely misunderstood constitutional questions to come before the Supreme Court in recent years: the scope of judicial power, specifically the power of lower federal courts to issue nationwide injunctions. The case before the court, Trump v. CASA, centers on an executive order by President Trump aimed at restricting birthright citizenship, a policy with sweeping implications for the interpretation of the 14th Amendment. But the legal question the court is deciding is not whether the executive order itself is constitutional. That question lies just beneath the surface. Instead, the question is procedural. If a lower court finds a policy unconstitutional, can it block that policy nationwide, or must it limit its ruling to the specific individuals or jurisdictions before it? Now, to most people outside the legal system, this question might appear technical or even academic, but as we dig into the arguments presented today, we'll see that this procedural debate carries enormous consequences for how constitutional rights are enforced in practice. Beneath the formality of jurisdictional rules lies a very real struggle over whether the courts can provide meaningful and timely protection when rights are violated at a national scale. Let's first understand the structure of the competing arguments. The challengers to the executive order, organizations representing individuals potentially stripped of citizenship, argue that when a court determines a policy is unconstitutional, that policy must be stopped from applying to anyone, not just the parties in the courtroom. Their rationale is simple: constitutional rights are not private possessions. They are systemic guarantees meant to apply universally. If the government has issued an order that violates those rights, courts must stop that violation wherever it occurs. Otherwise, identical harms will go unremedied in every state where the issue hasn't yet been litigated. Their warning is this: without nationwide injunctions, we will devolve into a legal patchwork. In one state, a child is a citizen. In another, born under the same conditions, the child is not. Families will be split across legal lines. Individuals will face wildly inconsistent treatment depending on geography. The Constitution will not be uniformly applied, and that, they argue, is a deeper violation than any procedural restraint on judicial scope. Now, the government presents a different concern. They argue that allowing lower courts to issue rulings with national reach gives a single judge too much power. If one federal judge can halt a federal policy across all 50 states, the administration becomes vulnerable to what it sees as judicial veto. The government says this undermines its ability to govern, to enforce its policies, and to navigate conflicting rulings from different jurisdictions. In their view, such power should be reserved for the Supreme Court alone. To illustrate the point, they claim that nationwide injunctions force them to respond to legal challenges everywhere, and that this makes national policymaking untenable. They fear that any controversial policy, no matter how lawful, could be paralyzed by one outlier ruling. This back and forth forms the core of today's debate, but both sides are doing something subtle and crucial. They are framing the issue as a contest of burdens. Each side claims that the other's rule would overload the legal system. The challengers say, if courts cannot grant broad relief, the burden falls on every individual harmed to sue on their own. This, they argue, creates a fragmented and inaccessible system where only the privileged can protect their rights. The government counters: if courts can grant universal relief, then a single plaintiff, in the right courtroom, can freeze an entire national policy, leaving the executive branch defending itself across dozens of jurisdictions. But here's the key insight, and it's one the court must take seriously. These burdens are not equivalent. This is not a symmetrical trade-off. One burden is structured and finite, the other is chaotic and unlimited. Let's look more closely. When a court issues a nationwide injunction, it imposes a burden on the government, yes, but it is a limited, coherent burden. The government must respond once, comprehensively. It knows the scope of the injunction, it knows which rules it must pause, and for whom. It may appeal, but until then, it has a clear directive. Compliance is administratively difficult, but legally simple. By contrast, if the court sides with the government's position and strips lower courts of the power to issue nationwide injunctions, what follows is not relief, but escalation. Suddenly, the only remedy for unconstitutional policy is serial litigation. Every affected person must find a lawyer. Every court must rehear the same arguments. Different judges will reach different conclusions. And implementation? impossible. Imagine trying to enforce a single federal rule that is valid in Georgia, blocked in Illinois, narrowed in Colorado, and half suspended in California. What the government describes as the more restrained approach is, in practice, an invitation to legal fragmentation. And that fragmentation is not neutral. It rewards delay, burdens the poor, and undermines the equal application of constitutional rights. It creates a system in which those who are quickest to sue, or who live in more sympathetic jurisdictions, are protected, while everyone else waits for clarity that may never come. That's why the challenger's analogy to a game of catch me if you can, as raised by Justice Jackson, is so apartment under the government's rule. People harmed by unlawful government action are left chasing justice through a maze of courts, hoping their case will be the one that finally forces accountability. But there's a deeper irony. The government warns that nationwide injunctions require it to respond in every jurisdiction. That is simply not true. A single injunction halts the policy once. It may later be appealed, revised, or overturned. But it creates a focal point of legal clarity. By contrast, removing that power does the opposite. It guarantees litigation in every jurisdiction. And because each ruling applies only to its plaintiffs, the number of suits grows exponentially. The same government that warns of judicial overload is advocating for the very structure that makes overload inevitable. So what's really at stake? This case is about how we structure judicial relief in a constitutional democracy. It is about whether we accept a world where every person must individually reclaim rights that are supposed to be universal. It is about whether our legal system aspires to order and coherence, or whether we accept systemic incoherence as the price of procedural purity. At the end of the day, this is not a conflict between overreach and restraint. It is a conflict between limited enforcement and unlimited fragmentation, between a single, manageable injunction and 1,000 lawsuits with 1,000 rulings, in a country that promises equal justice under law. The court must decide not just how rights are litigated but whether they can be protected at all.